Good afternoon, everyone. Hi, this is Ryan Rohlfsen with Rohlfsen Gray in Chicago. I'm here today with my colleague Brendan Hanifin, as well Amma Adams. Welcome to our webinar regarding international risks posed by digital currencies. And thanks again for joining us. Hope you find the program worthwhile, but before starting, we want to run through just a few reminders. First, the slides you see are available for viewing on the console you're currently logged into. You can also download the slides under the resource widget on the platform that you're logged into. A copy of the slides and a recording of today's program will also be circulated to all attendees tomorrow. Second, you'll have the opportunity to ask questions during the presentation. While the phone line will not open up for questions, you can submit questions by the chat function on the webinar portal. Nothing we say nor a slide should be construed as legal advice or a legal opinion in any specific facts or circumstances. Today's presentation is not intended to create a lawyer-client relationship, and you're urged to consult with your own lawyer concerning any situation or specific issues you may have. Finally, if you're interested in receiving CLE credit, there's an attorney affirmation form also in the web portal. You can download it by clicking on the resource widget on the webinar platform. At the end, we'll give you a code to add so you can get your credit. We are, I believe, approved for 1 hour of ethics credit in Illinois, New York, 1.5 hours of ethics credit in New York, Illinois, and California. And again, we'll give the code at the end of the presentation. With that, we'll go ahead and get started. So our agenda today is we're going to talk through the current landscape regarding digital currencies. Then we're going to move into how digital currencies are impacted with U.S. economic sanctions laws. We'll then move into AML applications. And then FCPA ramifications of cryptocurrencies, and then conclude with some very recent developments that are taking place in these landscapes with cryptocurrencies. So first of all, just a sort of table set. It's really, last few years has really been exciting in terms of what we've seen with cryptocurrencies and digital currencies really coming to the forefront. I suspect that 5 years ago, many of us didn't even really know much about Bitcoin or other cryptocurrencies. And in fact, a few years ago, Bitcoin was trading for very small amounts. And I think that most of us on the call know that by the end of last year, a single Bitcoin was trading for close to $20,000 coin. As you can imagine, this, of course, has spawned a number of cryptocurrencies to emerge as competitors of Bitcoin, as well as getting the U.S. regulators' interest in trying to understand the impact, both currently and in the future, of cryptocurrencies. And obviously, the areas we're talking about today are of particular interest to the regulators, with, as you would imagine, with respect to money laundering, sanctions, and corruption risks. At the forefront of regulation we're seeing is the SEC, Treasury, CFTC, and FDIC, all issuing warnings regarding digital currency investments. And all these agencies, to some degree or another, have pledged additional oversight. In particular, the SEC has been looking very closely at initial coin offerings, ICOs, to make sure that, in their view, they're meeting the appropriate hallmarks of securities registrations and are compliant with the securities laws. The U.S. is not alone, obviously, in that. The U.K., Switzerland, Korea, China, a number of other countries have started to issue regulations and looking very closely at the use of cryptocurrency as well as the issuing of initial coin offerings. With that, we'll turn to sanctions and my colleague Brendan Hanifin.
Great, thanks, Ryan. So slide 6 on your screen provides an overview of relevant U.S. sanctions regimes. I'll caveat here that U.S. sanctions come in many nuanced varieties, but for purposes of this presentation, we have grouped them into 3 separate buckets. First, country-based sanctions, or more accurately, comprehensive country-based sanctions, generally prohibit U.S. persons from engaging in any business or dealings with individuals or entities who are located or organized in Cuba, Iran, North Korea, Syria, and the Crimea region. The relevant prohibitions under OFAC's country-based sanctions programs are not identical across programs, such that it is frequently necessary to consult the regulations to understand the specific restrictions at play for any given transaction. The second bucket of U.S. sanctions is list-based sanctions. List-based sanctions prohibit U.S. persons from engaging in virtually any business or dealings with individuals or entities on the FDN list, as well as entities majority owned by FDNs. FDN designations, therefore, apply to any entity in which an FDN or multiple FDNs taken together hold a 50% or greater ownership interest. In practice, this means that OFAC sanctions extend to certain entities which are majority owned by sanctioned parties that are not themselves included on the FDN list. This, of course, can present significant compliance challenges, particularly when dealing with parties in jurisdictions like Russia, where ownership structures can be opaque, or in environments where reliable ownership information is hard to come by. The third bucket of sanctions, sectoral sanctions, prohibit U.S. persons from engaging in certain limited transactions involving targeted Russian firms, as well as entities majority owned by the government of Venezuela. Of course, the European Union, Canada, other countries, as well as the United Nations, each administer their own economic sanctions programs with their own restrictions and jurisdictional standards. U.S. sanctions prohibit U.S. persons from facilitating transactions by foreign parties with sanctioned persons if the transactions would be unlawful if carried out directly by a U.S. person. In practice, facilitation is a somewhat vaguely described concept whose technical definition varies across individual sanctions programs. The slide on your screen provides some common examples of impermissible facilitation, and later in the presentation, Amma will discuss an example of how a creative OFAC enforcement officer could apply the facilitation concept in the digital currency context. U.S. sanctions generally apply to U.S. persons, which include U.S. companies and their foreign branches, U.S. citizens regardless of where they are located, and generally regardless of the nationality of their employer, and any person physically located in the United States, regardless of their nationality. As compared to certain other legal regimes, U.S. sanctions have relatively broad extraterritorial application, and in fact, many of the largest U.S. sanction settlements have involved non-U.S. companies or financial institutions. All this is to say, non-U.S. companies ignore U.S. sanctions at their peril. In this regard, the first point to make is that the United States, Cuban, Iranian sanctions programs specifically apply to non-U.S. entities that are owned or controlled by U.S. persons. The middle box on the slide sets forth the test for ownership or control by a U.S. person. It includes three prongs: 50% or greater equity ownership, the right to appoint a majority of board seats, and a third catch-all category. While OFAC has issued guidance regarding the factors relevant to the determination of control under the catch-all category, application of those factors is necessarily subjective. This means that in cases where a non-U.S. entity has minority ownership interest by a U.S. person, and a U.S. person has some other indicia of control, companies may be forced to make risk-based determinations of whether they fit within the third prong of the ownership or control test. Second, certain aspects of U.S. sanctions apply to non-U.S. persons. For example, it's a violation of the Iranian sanctions for a non-U.S. entity to cause another entity to violate the U.S. sanctions. This could happen if a non-U.S. person were to cause an Iran-related payment to be processed through a correspondent account maintained in the United States or a foreign branch of a non-U.S. bank. Similarly, under several country sanctions programs, non-U.S. persons are prohibited from exporting U.S. origin products or services to targeted countries. Third, the U.S. maintains so-called secondary sanctions, which specifically target non-U.S. persons who engage in certain transactions involving Russia, Iran, and North Korea. Under legislation passed late last year, the President is authorized to impose sanctions against non-U.S. persons who knowingly engage in significant transactions involving sanctioned Russian individuals and their immediate family members. Similarly, the United States maintains certain secondary sanctions that target non-U.S. persons for engaging in transactions with Iranian individuals on the FDN list or the Islamic Revolutionary Guard Corps, or IRGC. The statutory penalties for violating U.S. sanctions are, in a word, severe, and include both civil and criminal penalties. In practice, the penalties imposed for violations of U.S. sanctions tend to be very fact and circumstance specific. Relevant factors may include the volume, value, and duration of the alleged violations, whether the violations were voluntarily disclosed to OFAC, the alleged violators' sanctions compliance history, and the adequacy of the alleged violators' sanctions compliance program. Pertinent to this presentation, in March of this year, OFAC issued guidance clarifying that U.S. sanctions apply to digital currency transactions and recommended that administrators, exchangers, and users of digital currencies adopt risk-based sanctions compliance programs. At this point, I'll turn the presentation over to Amma to discuss some of the sanctions-related risks presented by digital currency transactions and the challenges of adopting a sanctions compliance program that can effectively address those risks.
The sanctions risk associated with cryptocurrencies has certainly risen dramatically in the last few years. As Ryan noted at the beginning of this presentation, in a short amount of time, virtual currencies have emerged as an important payment platform in the global economy. It's important to remember that it was only in 2009 that Bitcoin was first launched, and since then there have been over 1,000 cryptocurrencies valued at hundreds of billions of dollars. While there are certainly many legitimate uses for cryptocurrencies, these currencies have also become increasingly attractive to sanctioned countries who are trying to minimize the impact of U.S. and other international sanctions regimes on their economies. As Brendan noted, U.S. persons are generally prohibited from engaging in any transaction with sanctioned countries, including the provision of financial services. Financial services is very, very broadly defined by OFAC. Now, the appeal of cryptocurrencies for a sanctioned country is that these currencies can be frequently used on an anonymous or pseudonymous basis, and they do not require sanctioned countries to have touch points with SWIFT or other financial networks, which would certainly be helpful for countries dealing with sanctions restrictions related to capital markets and access to the U.S. financial system. Iran, Russia, and Venezuela have already or plan to develop cryptocurrencies. President Putin's own economic advisor has stated that cryptocurrencies would be useful to carry out, quote, sensitive activity on behalf of Russia and allow Russia to settle accounts with counterparties all around the world with no regard for sanctions, end quote. Venezuela has also issued its own cryptocurrency, the Petro, reportedly, in fact, with the assistance from the Russian government. And recent statements by Iran suggest that the country is also looking to develop their own digital currency. The risk of dealing with sanctioned individuals or entities in many ways could be more challenging or raise more significant challenges than dealing with sanctioned countries. While the U.S., for example, has embargoes and sectoral sanctions against a handful of countries, there are over 7,000 individuals and entities that are designated or listed on the specially designated nationals list. And this list does not include entities that are 50% or more owned by an FDN. As of now, there is no truly effective system that truly addresses how to implement effective screening tools against anonymous or pseudo-anonymous currencies. OFAC, however, has stated that U.S. persons will have the same sanctions compliance obligations regardless of whether transactions involve real currencies or cryptocurrencies. To help users and companies and individuals with this process, OFAC has announced that it is considering adding digital currency addresses or wallets linked to sanctioned individuals and entities identified on the FDN list. This would put U.S. persons on notice that doing business with those digital addresses may be prohibited. There would be presumably a field on the FDN list for digital currencies with room for up to 256 alphanumeric characters and the name or the ticker of the currency. Now, how effective this tool will be is certainly a matter of debate. There's many questions that still need to be answered, and OFAC hasn't provided particular guidance yet. How would virtual currency recipients, for example, be able to block transactions? How will the screening work given the fact that wallet addresses can be changed and that many addresses are only used once? And finally, how will OFAC be able to track the actual identity of address users? Another concern that U.S. persons have to consider when dealing with cryptocurrencies is prohibited facilitation. As Brendan explained, there are several embargoes administered by OFAC that prohibit U.S. persons from approving or facilitating a non-U.S. company's transactions with an embargoed country if that transaction itself would be prohibited as to a U.S. person. It is possible, with the right circumstances and facts, that OFAC could take the position that conducting transactions in a currency where the user base is heavily concentrated or focused in a particular sanctioned country is prohibited facilitation. While we're not aware of any such enforcement actions on that specific issue, it is certainly something to be attuned to, for example, in the context of ICO participation. It is as of now low risk, but not something that can be ruled out in the absence of more formal guidance from OFAC on how these currencies are actually intended to work from a compliance standpoint. It is important to remember that there is strict liability for violations of OFAC sanctions. If you engage in a prohibited transaction that violates U.S. country-based sanctions, or if you deal with SDNs, you're potentially subject to significant criminal and civil penalties. Now, it's true that foreign persons may not have the same impetus as U.S. persons to be worried or concerned about OFAC sanctions. However, they should be concerned about potential liability, for instance, under the Foreign Sanctions Evader Regulations. Those sanctions focus on foreign persons who have facilitated deceptive transactions for or on behalf of persons subject to U.S. transactions. U.S. persons would be prohibited from engaging in all activities involving such foreign persons identified on that list. And with that, I'll hand the program over to my colleague, Ryan.
Yeah, so then moving into, I think, the next area we wanted to spend some time on is anti-money laundering. I think it's quite clear by this point that this is an obvious risk and a big risk for those who are transacting with Bitcoin or other cryptocurrencies. And obviously the regulators have started to pay attention. And a number of bank institutions and other large financial institutions have started to try to figure out how do we comply with AML if we're going to start accepting and transacting in cryptocurrencies, whether on our own behalf or for clients. Just a level set before diving into cryptocurrency-specific issues in terms of U.S. anti-money laundering legal regime. Basically two key statutes here at a high level. One are the criminal AML statutes, which prohibit U.S. citizens and U.S. organized entities from knowingly conducting or attempting financial transactions that involve the proceeds of a specified unlawful activity. And then, of course, we also have the Bank Secrecy Act and the Patriot Act that require financial institutions to establish and maintain AML compliance programs, including knowing your customer and those sort of things. And those financial institutions are defined to include banks, credit unions, broker-dealers, currency exchanges, insurance companies, credit card operators, et cetera. It's quite broad in that regard. In terms of the penalties that it may be imposed, money laundering is obviously a charge you see on many white-collar prosecutions, be it for sanctions violations, FCPA, wire fraud, those sort of things. Oftentimes you see an attendant money laundering charge because these penalties are quite severe. And in the criminal statutes, you can have fines up to $500,000 per violation, up to 20 years in prison, and of course criminal forfeiture and civil forfeiture under the Bank Secrecy Act, Patriot Act. Administrative fines can go up to $500,000 per violation, 10 years, up to 10 years in prison per violation, and those who work at financial institutions can have additional personal liability as well. FinCEN has issued some guidance with respect to compliance with AML laws. In 2013, FinCEN clarified that U.S.-based administrators and exchanges of virtual currency qualify as money services businesses, MSBs. They're subject to affirmative AML requirements, the compliance requirements of the BSA and Patriot Act. An administrator is someone who's engaged as a business in issuing or putting into circulation virtual currency and who has the authority to redeem or withdraw from circulation such virtual currency. An exchanger is someone who is engaged as a business in the exchange of virtual currency for real currency, funds, or other virtual currency. And the compliance program that must be put in place has to include written policies and procedures, a designated AML officer, and include testing, training, and risk-based customer diligence procedures. By contrast, a user who obtains convertible virtual currency and uses it to purchase real virtual goods or services is not an MSB and would not be subject to FinCEN regulations. Turning it over to Amma.
FinCEN has recently, in February of this year, provided some updated guidance on additional categories of entities or persons dealing with cryptocurrencies that would fall under their jurisdiction. In that regard, developers that sell convertible digital currency, including through an ICO, now qualify as an MSB. And as Ryan mentioned, there's certainly several different types of requirements that apply to MSBs that are dealing with these types of currencies. Some additional ones include reporting transactions of more than $10,000, or if a transaction is regarded as suspicious or criminal, filling out a report about the suspicious activity. There is one exception that FinCEN has noted to date, is that an ICO that is registered as a security would not be considered a money transmitter. And as of this time, FinCEN and the FCC and the CFTC are working to clarify obligations of businesses involved in ICO activities. In terms of the risks associated with cryptocurrencies and money laundering issues, the U.S. government and law enforcement is certainly aggressively focused on cryptocurrencies for a range of criminal and illegal activities. The U.S. government, in various agency statements, has stated that they consider cryptocurrencies, despite their legitimate use, to be a threat to the national and financial security of the United States. Now, in terms of liability under the AML criminal statutes, actual knowledge that you are engaging in a prohibited transaction is not necessary or required. It is sufficient for the government to be able to prove that you have a reckless disregard in a situation, for instance, where you are aware of facts that would cause a reasonable person to be suspicious about the circumstances of a transaction, but further diligence is deliberately put aside or swept away because you wish to remain in ignorance of the facts. Based on those circumstances, it would be possible for the government to satisfy the burden of knowledge. Turning it over to Brendan.
Great. Turning to the affirmative AML requirements of the BSA Patriot Act regime, the Department of Justice and FinCEN have brought enforcement actions against U.S. persons who operated unlicensed digital currency exchange businesses. In the Lord case summarized on the left side of your screen, the U.S. Attorney's Office for the Western District of Louisiana charged the father and son team for operating an unlicensed Bitcoin exchange. The Lords accepted traditional currency payments from their customers and exchanged those funds for Bitcoin, charging a commission. The Lords never registered this business with FinCEN, and the younger Lord also engaged in illegal drug activities. As indicated on the slide, the Lords received significant prison sentences for their activity. In the Ripple Labs case, summarized on the right side of your screen, FinCEN and DOJ brought enforcement action against San Francisco-based Ripple Labs, now known as Ripple, for acting as a money services business and exchanging virtual currency without registering with FinCEN. This case marked the first civil enforcement action against a digital currency exchanger. At the time, Ripple was the second largest cryptocurrency by market capitalization after Bitcoin. What's particularly notable in the Ripple Labs settlement is that the company undertook certain affirmative compliance obligations pursuant to its agreements with FinCEN and DOJ. For example, Ripple agreed to conduct a 3-year look-back to identify suspicious activity and committed to report that activity to regulators. In addition, Ripple was required to engage an external independent auditor to review its compliance with the Bank Secrecy Act every 2 years, and is required to report those findings through 2020 to FinCEN. Foreign-based money exchange businesses are not outside the scope of FinCEN's jurisdiction if they conduct sufficient amount of business in the United States. BTCE, a Russian cryptocurrency exchange platform, exchanges traditional or used to exchange traditional currency for Bitcoin and other digital currencies. BTCE did not collect KYC information from its customers beyond login credentials such as email addresses, passwords. The case also involves some very bad facts. For example, users of the exchange's website reportedly openly discussed criminal activity on the site's chat function. In addition, the exchange's employees allegedly provided advice on how to execute illegal transactions, including drug transactions, on the dark net. In sum, this was not a traditional non-feasance case, but appears to have been a situation in which BTCE actively catered to and perhaps even cultivated criminal activities on its site and using its digital currency. FinCEN imposed a $110 million civil penalty and claimed that after finding that BTCE and its owner willfully violated U.S. AML laws. The site was eventually taken offline. Now I'm going to turn the presentation back to Ryan for a discussion of the intersection between digital currency transactions and the FCPA.
Thanks, Brendan. When I first started thinking about Bitcoin and cryptocurrencies, obviously I think corruption, money laundering were one of the things that really came to the forefront. And I have to confess, as a former criminal prosecutor, I would think that. My corporate colleagues remind me that the vast majority of proposed transactions, of course, some estimate upwards of 99%, are meant to be very, quite legitimate transfers of money, and a way to speed up monetary transfers and make them obviously much cheaper and more efficient, and all those positives. But obviously, a big concern here is the anonymity piece. It's like having cash that you can move around without actually having it obviously physically present, which leads to many opportunities for unlawful activity, and corruption is towards the top. Just to sort of level set here as well for everyone that is not familiar with some of the detail of the FCPA, it obviously applies very broadly, both in terms of anti-bribery provisions that apply to any U.S. citizen, company, or agent acting on their behalf, as well as to companies that are issuers on a U.S. exchange. And of course, under those provisions, there are more detailed requirements for the maintenance of accurate books and records, as well as internal accounting controls to assure that those books and records are accurate. The key thing for the anti-bribery provision, of course, is you can't make an offer or promise to pay something of value to a foreign official, whether it's direct or indirect, in order to obtain a business advantage. So in thinking about the intersection of cryptocurrencies and the FCPA, one of the obvious things is giving something of value that could be a Bitcoin, as we mentioned earlier, valued today, something around, let's say, $10,000 per Bitcoin if you're to convert it to a paper currency, is obviously something of value and something that would need to be monitored. Violation of the FCPA carries numerous civil and criminal penalties were applicable certainly for all U.S. citizens and those working inside the United States on behalf of U.S. citizens. Violating the anti-bribery provisions could face jail time as well as large fines. Same thing for companies, of course. And there's a lot of collateral consequences we're familiar with big FCPA investigations, including reputational damage, costs, external monitors, and the like. So just to state clearly the obvious, which is to say that improper payments by digital currency would not be permissible in the same way it really be viewed as cash. So the interesting thing, of course, I think, is to try to think about how digital currency would be used to pay certain government officials, and how to intersect with the compliance program. And so the main thing there we think for compliance programs is, when companies are starting to see requests for transactions in digital currency as has started to appear, it's the same basic requirements that you'd have with respect to making payments by wire at this stage, which in other words, know who your third parties are, understanding where the payments are going, that they are for value, that they're fair market value, and the like. I think probably a good analogy is when you have a vendor who's requesting a payment in an offshore currency. So those things do happen. Some degree of regularity with businesses. Say, for example, you have a vendor in Africa who is looking for payments in Swiss francs, and that could be a legitimate reason, and it may not be, but it has to be looked at very carefully. And I think this is a similar analogy to cryptocurrency in terms of compliance program implementation. The big risk, of course, is that regulators are going to start looking more and more and assume that almost any cryptocurrency transaction is going to be suspicious, given the anonymity, the ease with which cryptocurrencies can be transferred among parties. Right now, the fact that there are so many different platforms developing cryptocurrencies, including, as Amma mentioned, state-sponsored actors as well as commercial actors. So we know not only Venezuela, Russia, but Korea is looking into it, Switzerland, Amazon, the retail is looking into it. A lot of companies are trying to think about how this will look in practice and trying to implement, which could lead to more opportunities for not only using the currency, but in terms of possible compliance violations in the future. Another sort of angle in FCPA that might not be super obvious is with the rise of these government-backed digital currencies, you have a situation where a number of governments are actually offering the currencies, offering members of the investing public the opportunity to invest in the currencies before they're launched. So whether it's at a discount or being able to provide access to, it's almost like a pre-IPO sort of pricing for the currency, limited supply of currencies being allowed to launch into the market. This obviously creates opportunities for interested investors who, with corrupt intent, who may want to bribe foreign officials with real cash or other sort of things of value in order to receive favorable access to the government's launch of a sovereign initial coin offering, and those sort of activities could lead to other potential FCPA violations for individuals who are involved in those transactions in the future. So turning it back over to Amma for a minute, we have a few recent developments in this space that are very interesting.
Yes, we're now going to highlight some recent developments in the growth of cryptocurrencies and some increased scrutiny and regulations that have come out in recent months around this type of currency. As you can see from this slide here, the Marshall Islands became the first country in the world to recognize cryptocurrency as its legal tender when it created its own digital cryptocurrency called Sovereign, or the SOV. It will have equal status with the US dollar as a form of payment, which is a significant development, and will likely lead to its acceptance on a more wide basis than some other cryptocurrencies that we currently see out of the market. The SOV will require users to identify themselves and therefore hopefully avoid some of the issues that have kept Bitcoin and other cryptocurrencies from securing more formal support from governments and international businesses and financial institutions. It's unclear at this time when the Marshall Islands will issue their currency, but their intention is to hand out 2.4 million SOVs to their residents for use. As I mentioned earlier, Venezuela announced that it was going to release its own form of cryptocurrency back in 2017 called the Petro, and that was backed by crude oil reserves. And one of the differences between the Marshall Islands SOV and the Petro is that the Petro is backed by crude oil reserves, while the SOV is going to be recognized officially under Marshall Islands law as a legal tender. In March of this year, President Trump signed an executive order imposing new sanctions against Venezuela for its Petro cryptocurrency, effectively banning U.S. persons from dealing with this currency. It's important to note that earlier in 2018, OFAC had noted that the use of the Petro currency appeared to be an extension of credit to Venezuela and warned that engaging in transactions with the Petro might violate U.S. sectoral sanctions against Venezuela. Venezuela has been quite vocal about its attempts to use the cryptocurrency as a way to circumvent international sanctions. And so this is likely what led President Trump to take a more aggressive posture in March of this year. And certainly Russia and Iran, who are contemplating the development of their own cryptocurrencies, will certainly be focusing on these recent sanctions developments from OFAC with respect to Venezuelan cryptocurrency. With that, I'll turn it to Brendan.
Great, thanks, Amma. So for much of the month of April, we've been following Russia and Iran's deliberations and eventually, most recently, attempts to shut down Telegram, the popular secure messaging application. Earlier this year, as you may be aware, Telegram announced a forthcoming initial coin offering and has reportedly raised over $800 million in initial pre-sale and is planning additional pre-sales in the months to come. Telegram is particularly popular in countries where internet access may be limited or closely monitored by the government, which would obviously include both Russia and Iran. As noted on the slide, Telegram actually consumed approximately 40% of Iranian internet traffic in January of 2017, which if you think about it, is a staggering number. Fortunately or unfortunately, the Russian and Iranian governments' attempts thus far to shut down Telegram have been clumsy, to borrow from the New York Times description. In Russia, after Telegram declined to provide encryption information that would enable the Russian government to identify users of the messaging service, and see the content of their messages, Russian government officials undertook an effort to obstruct millions of IP addresses to effectively shut down the Telegram service. The problem in this case is that the Russian government cast too broad a net and inadvertently disrupted the websites of multiple unrelated businesses, which in turn suffered financial losses. In Iran, and perhaps somewhat ironically, the supreme leader, Khamenei, is an active user of Telegram, and because Iran has announced a policy of essentially shutting down the Telegram messaging service, he was, I suppose, reluctantly forced to terminate his own account. In both countries, Russia and Iran, users are evading the shutdown, among other ways, by connecting to the Telegram service via VPN connections. So for anyone out there hoping that the government's crackdown efforts would somehow mitigate the risk presented by transactions in the Telegram ICO, Russia and Iran both being high-risk jurisdictions from a sanctions and anti-money laundering perspective, until the government becomes more effective in those efforts, you're unfortunately out of luck. Most recently, the Wall Street Journal reported that Coinbase had approached the SEC about registering as a licensed brokerage firm and electronic trading venue. Registration with the SEC, of course, would subject Coinbase to the same SEC requirements that apply to broker-dealers, and then issuers would be required to register their ICOs with the SEC. This development, in our view, highlights the steps that higher profile and I suppose more legitimate cryptocurrency firms are taking the SEC's warnings very seriously. As noted in previous slides, the SEC has issued numerous subpoenas and information requests around ICOs in recent months, and it appears that those warnings and certainly the subpoenas and information requests have succeeded in getting U.S. firms' attention.
Thanks, Brendan. And we had a few questions come in we can maybe just talk about for a minute during the presentation. First question was, how do you view as a practical matter considerations for institutional investors who are looking to invest in cryptocurrencies, some common pitfalls, things to consider for good faith actors? Why don't I start with you, Amma? What do you think?
I think some of the more practical concerns or considerations. I think the example that Brendan just went through with Telegram sort of highlights some of the issues where you've got a known platform that has a heavy user base, for instance, in a sanctioned country, and if you're looking to make an investment, certainly as a U.S. financial institution or U.S. business in that type of platform, there are certainly risks that the U.S. government through OFAC could see that investment as a prohibited dealing or perhaps a prohibited facilitation with sanctioned countries or sanctioned entities. So from a compliance standpoint, when an institutional investor is looking to make an investment, particularly a significant one, it's really getting to understand the platform, the digital platform that they're making the investment to, looking at their user base, doing sort of know your customer screening about that platform to see if there's any red flags or issues related to their business and the opportunities that they may be presenting in an investment.
Another question that we had just received was, practical handling the custody of cryptocurrencies. I think that's sort of interesting. I don't know that's been sorted out just yet. Obviously, there's the notion of the digital wallet and those services we're looking to contain and hold those currencies. And some of the we know of a number of institutional investors and banks who are looking into providing those services as well. And but I don't think that's really been sorted out. Amma, do you have other thoughts on that?
No, I think that's an area that's still developing. I think, as you pointed out, there's certainly a growing demand or appetite for secure custody infrastructure around cryptocurrencies. And, there's a number of companies out on the market working with wallet providers to develop these types of custody services and arrangements. I think the important thing is if someone is engaged in the business of providing custody services around cryptocurrencies and digital currencies, there's various mechanisms or protocols that are being tested and implemented across various systems, including the tracking of IP addresses, two-factor authentication, multi-signature authentication, and authorization. So I think there's, given the innovation behind these currencies, there's a lot of innovative tools that are being developed to help make sure that those engaged in the custody of these currencies are not taking on any potential assets that might be tainted or be for the benefit of sanctioned countries or sanctioned persons. So I think it's definitely a space to watch because as these companies develop, it provides a little bit more certainty in the marketplace.
Ryan, earlier in the presentation, you noted the FCPA risks associated with digital currency transactions. And as noted in the slides, obviously digital currencies are a potentially very attractive medium for commercial bribery. We received an inquiry on how the U.S. government may view commercial bribery and potential avenues for prosecuting unlawful conduct that doesn't fall within the four corners of the FCPA.
Yeah, so commercial bribery isn't going to fall within the FCPA, but it is illegal under most state laws. And then as a consequence, once you engage in any degree of interstate commerce, and a cryptocurrency would be, you then implicate federal law, in particular the Travel Act, which would make commercial bribery a federal crime as well as a state, on top of the state charge. So, the one thing about the Travel Act is it's very infrequently used by U.S. federal prosecutors to bring standalone charges, although it does happen. They are often, however, attendant charges. So, for example, if the DOJ is looking at foreign corruption by a company, regardless of the topic, it may be just a run-of-the-mill bribery case not involving crypto, but if it learns of potential other misconduct by the company or certain of its individual employees or agents in the U.S., for example, and providing some sort of commercial bribery situation, you could see a scenario where, an executive from company A provides a cache of cryptocurrency to a procurement director of company B in order to secure lucrative commercial contracts. That would be subject to the Travel Act in all likelihood and may get the interest of the U.S. criminal authorities. I think more broadly speaking, the U.S. is somewhat unusual amongst the leading Western nations in terms of having that distinction currently with commercial and public bribery. UK Bribery Act, of course, which is one of the more modern statutes, does not make that distinction, and most countries in the Western world have been following that kind of regime, which is to treat them all the same. So that said, as most of the global regulators that are looking at those sort of corrupt payments have been focused on those going to public officials, but obviously in the right case, particularly when the amounts get higher, you certainly could see that as well. So of course that's a little bit of chicken or the egg, or cart before the horse, or however you want to redo the analogy, but a company's going to have a cryptocurrency reserve in order to give it away, unless actors are kind of employees are acting on their own behalf in doing so.
Great.
Another question for you is, question was talking about, we've thrown around the terms cryptocurrency, digital currency, blockchain. Can you just to level set, talk a little bit about what those mean just for everyone?
Yeah, they're fairly, used in the industry and by regulators interchangeably. Cryptocurrencies are seen as a variety of digital currencies, and they all have a virtual aspect to them in the sense that they can be used on the internet or other types of computer or related systems. So I think we've used them interchangeably throughout this presentation, but the common theme in all of those digital currencies versus the cryptocurrencies are there currencies that can be used to purchase goods that have some sort of associated value with them and can be exchanged for other forms of currency if a user so wishes. So they're generally seen interchangeably.
Great. With that, I think we've concluded our presentation today. As mentioned at the opening statement, if you're interested in obtaining a CLE credit, the CLE code today is 3604, and you just simply write that on the affirmation form, sign it, and send it back to cle.team@ropesgray.com, and that information should be on the form as well. Again, the CLE code is 3604, and that's for attorneys who want to receive ethics CLE credit in New York, Illinois, or California. This concludes our program. Thank you all very much for joining us. If you'd like further information on this topic, feel free to contact any of us. Our contact information is listed on the console. We hope to see you again soon. Thank you.